Good afternoon. Our second and last case on the docket today is 1,000 Friends of Florida and Robert J. Howell versus Dane Eagle as the Executive Director of the Florida Department of Economic Opportunity. Counselor for the appellants, you may proceed when you're ready.
Thank you, Your Honor. My name is Richard Grosso, and I will be representing the appellants, 1,000 Friends of Florida and Mr. Howell. The area of law that this case concerns does not have an extensive body of case law on it. It's a fairly obscure law. I think understanding this case requires a little bit of understanding of how the statute that has been amended here is supposed to work. And as that speaks directly to the two questions on the table. Are my clients proper parties to bring a challenge to this case, this law? And is the Department of Economic Opportunity the proper defendant? You need to understand a little bit about how this law works. First, the nature of the cause of action as it comes to standing, and we've cited to the court the Hayes case that says, standing depends on the nature of each case. The nature of the interest involved determines standing. There's one size fits all requirements in terms of concrete injury. In fact, it's not speculative. But when the court is applying those tests, it has to do so in relation to the specific kinds of interests that are involved in this case. In our case, the 1,000 Friends of Florida's reason to exist, it was created after the adoption of this law, originally back in 1985, to represent its members to enforce the statutory requirement that is at issue here, that's been amended here. That statutory requirement, and it's all one requirement, and so much of this argument bleeds in between and addresses both standing and a proper defendant. The legislature wrote a statute that said, we are going to establish this scheme that requires every city and county to write a comprehensive plan. And then the reason we're doing that is that every development decision that city or county makes forever thereafter has to be compliant with, consistent with that plan. That's the statutory purpose. That's the statutory scheme. That's why this law exists. 1,000 Friends of Florida's reason to exist is to represent its members to enforce both aspects of that statutory intent. If it cannot bring legal challenges to development orders to enforce the comprehensive plans, its reason to exist is completely thwarted. It cannot do what it was created to do.
Well, and let me pause and ask you a question there. You say it cannot do that, and how and elaborate on that. I think the appellees would argue that they just cannot do that against DEO as the party.
Well, the point that I'm making is they cannot enforce comprehensive plans at the local level. They cannot bring the enforcement actions this statute on one hand authorizes. If by doing so, and they shoot and miss, they bring a good faith case, it's grounded in good fact and law, but in the arguable cases that these are, they end up losing. They're automatically having to pay the attorney's fees of both the local government that issued the development and the landowner or the developer who received that permit. That is a risk that's unacceptable to all but maybe a handful of Floridians who have the financial wherewithal to run that risk. That's the huge problem here. And that's what gets us into these cases, the MedImmune case, the Steffel case, the Babbitt case at the federal level, the other cases we've cited you at the state of Florida level, where the cases have said standing does not require that you put yourself in the line of fire first and take the hit, that you receive the injury. Standing only requires a realistic threat of injury, that you stand to lose, you stand to be directly or indirectly affected. You've got a reasonable fear. The cases have rejected claims that you have to be hit with the sanction. You have to be convicted of the crime. You have to experience the penalty, the sanction, the adverse effect before you can be recognized to have standing to challenge the law that would inflict that harm on you. That's the law that the department has argued on appeal here, and the courts have rejected that. You do not need to wait until you've actually received the harm. If that's the law, if the law is as the department argues here, then there won't be a lawsuit ever brought unless there's somebody with the financial wherewithal to say, I'll take the risk, I'll put myself in harm's way. Then the legislature would have essentially legislated away any potential challengers from this law. The harm that this law inflicts, which it has been inflicting every day since it was enacted, is the kind of harm talked about in the MedImmune and the Stoffel and the other cases.
Counsel,
Yes.
this sounds a lot like a substantive argument that you're making here as to why the amendment is constitutional or not. And I think we're getting a little bit far afield from the issues involved here. We've discussed already, which is your standing, but I actually would like to hear a little bit more about this particular lawsuit and why you can raise your interest in striking the statute in this particular lawsuit, and in particular against this particular defendant.
Yes, Your Honor. And there is some crossover there, but the point I'm making is that 1,000 Friends of Florida is harmed by the inability to do its job, to fulfill its purpose, to bring these kinds of lawsuits because of the exorbitant threat of financial sanctions. That's why they're harmed. That's the point that I'm trying to make there. As to the question of the proper defendant, the Apthorpe case is controlling here. In the Apthorpe case, the court dismissed, there was a law enacted that applied, a law concerning growth management. And the challengers to that law sued the governor, the attorney general, secretary of state, and one other state officer. And the court dismissed all of them and said the State Land Planning Agency, the Department of now Economic Opportunity, is the proper party to have defended that lawsuit. It's a law on the subject of growth management. That's what that agency does. That's the agency responsible.
I'm sorry, Counsel, was that the Atwater case? I know there's a lot of cases that are have been briefed, but I believe
Yes.
it was the Atwater case. And that one thing that gives me pause for relying on that case for the proposition you just made is that it, certainly that was dicta in the case. There was no analysis provided in that portion of the opinion as to why then the Secretary of Community Affairs would be the responsible official. And then, of course, the statute was completely different than the one that we're dealing with now. And of course, these are points made by the appellee. Could you address them, please?
Yes, Your Honor. There was not a lengthy analysis in Atwater, but here's the analysis that supports Atwater. The law it was speaking to was a categorically, broadly speaking, a law on growth management. It was 2009, Chapter Law 2009-96. That law addressed a lot of things that the Department of Economic Opportunity directly is responsible for, but it also addressed several issues that the department is not responsible for. That law addressed property valuation for properties and structures used for affordable housing. That law addressed dispute mediation between local governments. That law addressed security and sanitary requirements that applied to cities and counties. It applied that law to local zoning changes, like the kinds of development orders.
Counsel,
under this law.
From what I can tell, that kind of proves Chief Judge Ray's point that the court did say, well, it looks to us like this is something for community affairs. But what you're telling me, what I'm hearing from it, is that there, in fact, was a lot of things in that law which did not necessarily involve community affairs. And maybe it's best that we not rely on Atwater as saying that any possible amendment to Chapter 63, the community affairs, or in this case, the EO, of course, is the proper defendant.
What's important to understand about Chapter 163 and its direct relationship to the statute subsection that was amended here was 163, 3161 explains, the purpose of this act is to establish and implement comprehensive planning programs to guide and manage future development. The intent of this act is that comprehensive plans have the legal status set out in this act, and that no development be permitted that violates a comprehensive plan. The cause of action that has been amended here to immediately hit an unsuccessful plaintiff with attorney's fees is the culmination, the very end result of the Department of Economic Opportunities comprehensive plan and plan amendment review process. This particular statute is not some side issue that's only tangentially related to DEO. I know the department argued in its brief that these sections of the law have only proximity in the statute with each other. That's just not accurate. That is not this law. This is part 2 of part 1. If this subsection didn't exist, if what the courts have said is this is the primary enforcement tool, this entire statutory scheme that DEO oversees and implements cannot be fulfilled, the cases have said, without citizen enforcement. There is a direct relationship between this subsection and the comp plan review that the department does.
Let me try this another way, and pardon my ignorance, but of course, we're not dealing with an actual challenge here, so you've dealt with them a lot more than I have. But it seems to me that if the department, has this overall responsibility of enforcing and implementing Chapter 163, and in particular the comprehensive planning, then if a local government submits a development order that is contrary to that comprehensive plan, it seems to me that the department, well, they'd be on your side, that a development plan that violates the comprehensive plan would actually be contrary to what DEO is trying to do. So how is it that they have an interest in the case that's adverse enough to support there being a defendant in this lawsuit?
Except that the way the statute set up the process, it doesn't work that way. The legislature decided that when it comes to that end result, when it comes to enforcing the comprehensive plans, only local citizens, locally elected people, have the standing to bring those challenges. The scope of those challenges is in turn limited by the content and the substance of the comp plans that DEO approved. But DEO does not have the legal jurisdiction to challenge development orders. The legislature decided it would be best if that enforcement happened locally in front of local circuit court judges by locally affected people. That's the nature of the statutory scheme they set up. That would have been maybe a valid approach for the law to take, what you suggested, but that's not how the law is structured. And that's the point, is that you can't have one without the other. This 3215 cause of action to enforce comprehensive plans exists to implement the department's decisions on the content, the substance of comprehensive plans. They're not unrelated. The department cannot, I think, assert really that it has a cursory interest only. If this law can't be enforced, if development challenges can't be brought by locally affected citizens because they're frozen out, as the Minto case that we cited that you talks about, then everything the department does, the two-step review process for comprehensive plans and the state agency review of all of that, and parsing word for word to make sure comprehensive plan language meets the statutory requirements, all of that is meaningless if people can't enforce those comprehensive plans. And I think fidelity to the department's legal responsibilities to oversee comprehensive planning, to approve of the content of those plans, make sure they meet the state requirements, then to be enforced by local citizens, the fidelity of that requirement requires, I think, the court to recognize the department is the only agency that could be the proper defendant here. This is part and parcel of their statutory responsibility. And if not them, who? If the department's argument is the proper defendant will be a local government or a developer when people bring a development order challenge to challenge a development order. But our point here is that that day is likely never to come because of the chilling nature of this law that anyone who tries to enforce this law, then on one hand says it's to be enforced, and the courts have said that enforcement is necessary to meet the statutory intent, that day's just not going to come, because nobody's going to be brave enough to take that risk. And so the case, that issue will just evade review. And every day since May of 2019, when this law became effective, just like the MedImmune and the other cases we briefed have talked about, people are not choosing not to put themselves in harm's way. The harm is every day that development orders are being approved, and nobody has the guts to take the risk of the financial risk to bring the development order challenges because of this law, which hopefully the court would remand back so we could get to the merit of the constitutionality of the law.
Mr. Grosso, your time has expired, and I believe, Madam Clerk, if I'm not mistaken, you used your rebuttal time. However, I'd like to extend your time by a minute and do so the same for Mr. White.
Thank you. So I should end now and have a minute of rebuttal. Is that
yes?
I'm hearing? Thank you. Thank you, Your Honor.
You're welcome, Mr. White.
Yes, Your Honor. Thank you. May it please the court, Brandon White on behalf of Mr. Dan Eagle, now as Secretary of the Florida Department of Economic Opportunity. Your Honors, in this case, what the appellants are seeking is an impermissible advisory opinion as to the constitutionality of a statute that they simply disagree with. We know that it's impermissible, and it's an advisory opinion that they're seeking because they are sustaining their action based on injuries that are purely speculative, are purely hypothetical, are someday off in the unknown future. And they're bringing their case against Secretary Eagle, who has no enforcement authority over the statutory provision that they're actually challenging. And so for that reason, the court below was correct to dismiss this case on the grounds of lack of standing, lack of a justiciable case or controversy, as well as holding that DEO and Secretary Eagle were not a proper party to that challenge. I think that there's a fair amount of overlap in some of these issues. So if the court wants to direct me towards something of interest, please feel free to interject. But if not, I think it makes the most sense to start with the absence of a justiciable case or controversy in this matter. That seems to be with the fair number of cases that this court has heard, in challenges like this, touch on. But if I could briefly to respond to appellant's argument a moment ago with respect to this being an obscure case law case, it's not. The case law is clear on all three of the issues that we're touching on here today. But again, justiciable case or controversy, we know for that to sustain a DEC action, for there to be a justiciable case that warrants a DEC action, there has to be a bona fide dispute. There has to be an actual practical present need for the court to invoke its jurisdiction and actually provide to render an opinion as to whatever plaintiffs may be seeking. And as part of that, there has to be an actual imminent threat of injury. There has to be an adverse and antagonistic interest between the parties. And those elements, those things simply are not present here. What we've got is a prevailing party fee statute, a cost shifting statute under section 163.3215 subsection 8 that takes place at the very end of a civil process where plaintiffs may challenge development orders that they believe are inconsistent with the comprehensive plan that a local government puts in place. What that means is for there to be attorney's fees awarded under that statute, first of all, there has to be a development order put forth by a local government first. That local government needs to not have enacted the quasi-judicial proceedings allowed for under 3215 under subsection 4, leaving a plaintiff to challenge under subsection 3 in a circuit court. Third, that development order needs to adversely impact somebody. And fourth, that development order needs to at least arguably be inconsistent with the comprehensive plan. The appellants in this case are jumping straight to step 5. And they're saying, we don't know where, we don't know when, we don't know why, we don't know what, we don't know how, but someday there's going to be a development order that meets steps 1 through 4 that I just articulated. And when that day comes, we're going to want to challenge it Moreover, we know for a fact that this prevailing party fee provision is going to, I believe in their allegations, they say it's going to make it economically infeasible for them to bring that challenge. And even that fifth step is not something that we're prepared to concede. It's entirely conceivable that 1,000 Friends of Florida may wish to bring a challenge that they feel is a dead ringer. It's a sure thing, and they'd be thrilled to have this prevailing party fee provision that would benefit them on the back end. So again, I guess to continue the baseball analogies from the prior case before the court today, they are swinging for the fences before the game has even started and before the other team has even shown up. And so for that reason, there is no justiciable case or controversy. There is no standing here. There has to be an actual or imminent injury or threat of injury, and that's simply not present. Turning to the concept of an adverse and antagonistic interest with respect to Secretary Eagle, that again is not present here. DEO does not enforce this provision. As I said, 3215 challenge to a development order that a plaintiff believes is inconsistent with the comprehensive plan, that's going to be brought by an individual or possibly another local government that believes that it is adversely affected. DEO does not bring these challenges. And likewise, the challenge is going to be brought against the local government who issued that development order that's the subject of the challenge. And again, that's not DEO. And so there is no adverse and antagonistic interest here to satisfy either the issue of a justiciable case or controversy or standing. And so for that reason, the court below was correct to dismiss on those bases. But again, getting over to the next issue that overlaps a fair amount is this concept: DEO and Secretary Eagle are not proper parties to these.
So let me ask one question. And again, all these concepts are interrelated. So I don't know if this goes to standing or justiciable controversy, but one of the arguments that was made in the briefs is this strict 30-day timeline for bringing a challenge to a development order. Basically, it's too short a time for an individual to determine or actually find out that the development order exists, make an informed decision whether to challenge that development order, test the constitutionality of this attorney's fees provision, get a determination by an appellate court in time to meet this 30-day window. So if you could respond to that argument, and again, I think it goes to perhaps one or more of these interrelated issues.
Yes, Your Honor. So with respect to that, these development orders, number one, are not issued in a vacuum. And so the idea that an interested party is not going to be aware until the day that the order is issued, and then the clock starts ticking, and then they've got 30 days to get everything together and bring that challenge. That's incorrect. But number two, this challenge that they're attempting to bring here could be brought as part of that development order challenge at the same time as part of a DEC action. And that would be permitted with respect to the local government because they are party to that action, and they could address it then. So the idea that this constitutional challenge that they are attempting to bring far too early against DEO as an improper party, they could bring it against the local government, and that would be addressed.
And so, and you're talking about in the development order challenge itself, and so would not that expose them to attorney's fees under this prevailing party statute?
I don't think so, Your Honor, because in the statute itself, it allows for attorney's fees with respect to the development order challenge. And so a DEC action that would be made part of that case, attorney's fees would not be appropriately assigned as part of that challenge. So they could bring it against the local government as a DEC action in the beginning of that case. And it could be, the rest of the case could be stayed. They could resolve that issue at the forefront, and it could be addressed. And to go back to this concept, this injury that appellants seem to take for granted, I'd be curious again to see whether they would want to do that in every single case. And who knows how that would play out. And again, just having to explore these different concepts shows just how premature this challenge is. And so that's part of the, wrapping your head around some of these arguments that are being made by the appellant is it requires pure speculation. And we know that that's impermissible. We know that's impermissible under Apthorpe v. Detzner. We know that's impermissible under Florida Consumer Action Network. And both of those cases out of this court dealt with cases in which there was no justiciable case or controversy because those plaintiffs seeking to bring DEC actions to challenge the constitutionality of the statute, their injuries that they were speculating upon, that they were alleging, were purely hypothetical. They were nowhere on the radar of the court to warrant invoking that jurisdiction to issue the declaratory judgment. And so moving back to DEO and Secretary Eagle not being a proper party defendant, we know from this court's cases over the last 10 years or so, particularly with respect to Scott v. Francati, we simply refer to it as the Francati test in our brief. We know that's a two-prong analysis for determining whether a state official is a proper party defendant to a challenge such as this. The first prong is, does the state official enforce the statute that's being challenged? The second prong is a two-factor prong, the first of which is, does the action involve a broad constitutional duty that implicates the responsibilities of the state official, and does the state official have an actual cognizable interest in the action? And neither of those prongs are met here. As I mentioned before, with respect to the first Francati prong, DEO, Secretary Eagle does not enforce this provision. Appellants in their brief go at great lengths to stretch that concept over into statutory scheme, or it's in the same chapter. And we know from this court's opinions in, as I said, Scott v. Francati, in Atwater versus the city of Weston, in Herodopolis versus Alachua County, Marcus versus the state Senate for the state of Florida. All of those cases where this court considered that analysis looked specifically at the statute that was being challenged, not the statutory scheme. And that's correct. And so the first prong, it's not met here. So the second prong is there a broad constitutional duty that implicates the responsibilities of this state official? There is no broad constitutional duty here. That factor came out of the concept, I believe it was in 1995, a case involving a constitutional requirement to simply provide education for the people of the state of Florida. And there were a number of parties to that case where, that's the sort of broad constitutional duty that Francati and its progeny are talking about. But even if you do accept that that's a broad constitutional duty, it does not implicate the responsibilities of Secretary Eagle. Secretary Eagle has no responsibilities relative to that challenge any more than the Secretary of the Department of Children and Families, for example. And so, again, they wouldn't be a proper defendant to this suit either, and neither is Secretary Eagle. And so if you just simply look at that first factor of the second prong of Francati, we know that DEO is not a proper party defendant. But if you go to the second factor, again, there has to be an actual cognizable interest in the challenge on the part of the state official. And again, that is not met here for all the reasons that we articulated. And that is, Secretary Eagle does not bring these lawsuits, these challenges to development orders. He is not the defendant to those challenges. He cannot enforce the provision. He's never going to be awarding attorney's fees to somebody prevailing in those development order challenges.
Counsel, this is somewhat of a follow-up question to a question Judge Winokur asked earlier. So I believe DEO could not bring these challenges to local development orders. Is that correct?
That's correct, Your Honor.
Consistency statute. Okay. And so to a certain extent, their interests are aligned with those that can under the statute. And so I think the argument is, so why isn't that an interest that would, allow it to be named as a proper party in this particular case? I mean, DEO obviously has some role to play with respect to comp plans. And if it can't make the challenges, and it has to rely on citizens and groups to do so, would not the proper party status be appropriate here?
Respectfully, Your Honor, no, it wouldn't. Again, it's number one, to go back to the concern that I expressed with respect to standing in justiciable case or controversy. This entire analysis requires us to speculate about the strength of the case and what's actually being challenged and what the problem is that appellants may be seeking to address at some unknown time in the future. But moreover, as was being touched on by appellants at great length, I don't think for this proposition, but I think it's correct, is that the legislature has specifically left DEO out of this process under these section 3215 challenges, and that's by design. And so to take a secretary of an agency that the legislature has completely left out and said, okay, DEO, and the legislature is aware of Chapter 163 in the Community Planning Act, and they've elected DEO to be excluded, to thrust Secretary Eagle into the defense of the constitutionality of that statute. It doesn't make any sense. It's I guess at its base, it's a separation of powers problem. Because you're asking an agency head to defend a statute that they have no interest in. And so we agree with appellants on the one thing, and that's that the legislature specifically left DEO out. If I could touch briefly on the Atwater case, I think, Your Honor, Judge Ray, you're right, it is completely dicta, but to any degree that it's not, Section 3215 was not addressed there. It was left out completely. And so it's not binding on this court, and I don't think it's apropos of anything in the court's analysis here with respect to this case, the issues of a justiciable case or controversy standing or DEO as a proper party. And so for all those reasons, we respectfully ask that this court affirm the ruling of the court below and hold that dismissal based on standing, lack of a justiciable controversy, and DEO as an improper party should be affirmed. Thank you.
Thank you, Mr. White. Mr. Grosso.
Yes, Your Honor. In the Francati case, and I quote, "Neither does the plaintiff allege that the nursing home pre-suit statute involves a broad constitutional duty of the state, implicating specific responsibilities of Governor Scott, or that Governor Scott has an actual cognizable interest in the challenged statute." The department's argument that it does not have an actual cognizable interest in the statute is not a reasonable argument. DEO's argument is theory. It does not acknowledge the functional relationship of the 3215 cause of action to its responsibilities in overseeing comprehensive planning and the development order consistency requirement. Advisory opinion, Chapter 86, the Childs case, say the Watson versus Clofton case, Florida Supreme Court. The purpose of the DEC action statute is to relieve parties from the insecurity. It's an instrument of preventative justice, says the Watson case. That's what we're asking for in this case. There's nothing speculative. There was confusion about 3215 cases. There's nothing speculative. If you bring a 3215 case and you do not win, you are automatically liable for attorney's fees to both defending parties. There's nothing speculative about that. This is a facial challenge to that. We don't need to know the details or the substance of any of those challenges.
Thank you, Mr. Grosso. Your time has now expired. Thank you very much for your argument. Also to Mr. White. This concludes arguments for the day. The court is now adjourned. Have a good afternoon.
Thank you.